The surgical symphysiotomy payment scheme commenced on the 10th of November 2014. It was estimated at the time that 350 women would apply to the scheme, but in fact 576 applications were accepted. Applications are being assessed by former High Court Judge Maureen Harding-Clark. The scheme has in the region of 34 million available, and participants will receive awards at three levels: 50,000, 100,000 and 150,000. The scheme was designed to be simple, straightforward and non-adversarial, and aims to minimise the stress for all women concerned. It was designed following meetings with all three support groups, two of which have welcomed its establishment. It was established to give women who do not wish to pursue their cases through the courts an alternative, simple, non-adversarial option in which payments are made to women who've had a surgical symphysiotomy, whether or not negligence is proven. Judge Clark has informed my officials that as of the 22nd of May 2015, 206 offers have been made to women, including one offer that was rejected. 194 of those offers have been accepted, with 11 offers awaiting response. Of the 194 offers accepted by applicants, 118 were assessed at 50,000, 71 at 100,000 and 5 at 150,000. A large number of applications have been made without medical records or evidence of symphysiotomy, and this information is being sought by Judge Clark in order to progress the applications. Where there was a delay arising on the compilation of a woman's supporting documentation due to difficulty in obtaining medical records, applications were accepted by the scheme, provided that the application was received within the time period set out in the scheme, with a written explanation of the reasons for the absence of the supporting documentation. The scheme is voluntary, and women do not waive their rights to take their cases to court as a precondition of participating. Women who opt out of the scheme at any stage in the process up to the time of accepting their award. It is only on accepting the offer of an award that a woman must agree to discontinue her legal proceedings against any party arising out of symphysiotomy or pubiotomy. The Deputy may be aware of a High Court judgment that was delivered on the 1st of May 2015, where the judge dismissed the claim for damages by a 74-year-old woman who had a symphysiotomy 12 days before the birth of her baby in the Coombe Hospital in 1963. The judge ruled that even though the woman had suffered since the operation, the practice of prophylactic symphysiotomy in the view of the court was not a practice without justification in 1963. The judge also in his judgment said, and I quote, "Though I would in the words of Sir Ranulph Crewe, Chief Justice of England, take hold of a twig or twine thread to uphold the plaintiff's case, I must find that this remarkable lady, whose story indeed deserves to be told, must fail in her case against the defendants." While the government is aware of the comments made by the UN Human Rights Committee, it believes that the provision of the ex gratia scheme, together with the ongoing provision of support by services by the HSC, including medical cards, represents a fair and appropriate response to this issue.
Sadly, Minister, I think the UN Human Rights Committee will be disagreeing with you at its next hearing. I think the fact that these elderly women who were butchered in their youth, who lost connections with their children, relationships with their husband, lives lives of continued pain, are being forced to go through this scheme is unacceptable. I mean, you've made the point yourself. The overwhelming majority of these women have been given a paltry payment of between, most of them, €50,000. That is 1/3 of the amount that the judge who is administering the scheme is going to get in a year. So the 5 people who got the maximum payment for a lifetime of agony are still getting less than what the judge gets for a year's work. I mean, that to me exposes the severe limitations in this scheme. I think the criticisms made by the UN about the fact that people were being exonerated for their role in this, that nobody took responsibility for it. I'm aware of the recent court case, but that will be taken further. And I think on human rights ground, Minister, you are going to have to revisit this because it simply isn't good enough.
Very quickly. Look, the United Nations Committee has the freedom to offer its opinion on any matter it wishes to offer an opinion, but in this country we're ruled by our laws, and justice is administered by our courts. We are an independent sovereign state. It is up to the women individually as to whether they want to apply for this scheme, in which they can accept or not accept. The vast majority have accepted, and they don't have to prove negligence in any case. Those, with the exception of symphysiotomy on the way out, those who have gone to court have not been able to prove that the practice was not without justification at the time it was done, to quote the judge.
Thank you. That completes questions for today.